In the meantime, I'll talk to our guest here. Matthew, let me ask you about this. When you're the defense and you're laying out an opening statement like that, isn't it dangerous to start down a road about something that can easily stick out in the jury's mind, like a red car? They were after the, they got this call to go look for something, and here is evidence coming in that says these guys knew 2 hours ahead of time that this guy's car was not even one they were looking for.
Yeah, well, Carol, I think we're having deja vu. It reminds me of the last time I was here on the Beard case, where I think the defense attorney in that case, not to pick on him again, but I'm still mad about that one, made the classic rookie mistake by laying out in his opening statement something about a punch card that the guy was at work, and that he never punched out, but that's not unusual. So he introduced something that later on, I think, helped to convict Mr. Beard. Again, over here, classic mistake. Why open with such a detailed analysis? Number one, you can't always believe your clients. Number two, what does it advance your case? You're going to have plenty of opportunity to develop your case, but it's better to sit back, make a general opening statement with rare exception, and say, just ladies and gentlemen, please keep an open mind. You know, the prosecution's going to go first, then we're going to cross-examine their witnesses, and if we choose, if necessary, if for whatever reasons, we may put on a defense, the defendant may take the stand, but we're under no obligation to do anything, and leave it at that. Don't get caught continually with your pants down. You have enough problems.
Well, not only that, couldn't you have gotten away with the fact that you're in a neighborhood, in an area in front of a known crack house, and therefore whatever your activities might be, like getting out, being very suspicious, makes more sense, and that it doesn't need a lot of explanation as opposed to this little red car that's standing out there?
You could stick, and I've done it often, you can stick to things that you know are going to come in. The evidence will show Malice Green had 0.5% of cocaine in his blood. The evidence will show Malice Green had a criminal history of violence and drugs. The evidence will show that witnesses testified that there was a struggle. And the evidence will show that ultimately and unfortunately and tragically as a result of this struggle that Malice Green met his death. And that's it. But the evidence will also show that my client is not guilty beyond a reasonable doubt. The evidence will show and go on and develop it. And leave it at that. And pick your points during the trial and make your summation.
Well,
don't put yourself in a corner that you may not be able to get out of.
I think this little red car is going to go down there and mow someone down. We'll take a break and come right back. Please stay with us.